Make your mama proud, popping it like shot. Turn up, it's a gangster party. PT ain't never popped a Mari, but if I ever catch Mac, I'ma pop a Harley. I don't even rob a cop the Harley. Blowing so much green, I shame Marley. Yeah, I push the line to its full limit. Hit the hole like 22, boy, I'm a young Emmett. Nothing go like snow, now that's a cold image. Still whistling, sending, knocking them white women. Only reason I do it to avenge Emmett. To the day they go before they box me out. Knowing me, it don't matter, I simply change my route. On my hobby.
West. Welcome to the Damu Kiwe Conversations, home of the West Coast, the voice of the culture. The still seems the done. We right back at it just like a crack addict. And if you didn't know, make sure that y'all bang that like button on y'all way in. Go tell a friend y'all in here with the Don. The name is DUSE. You know what I'm saying? Big Suge coming home. Hey, Suge Knight being released from jail 2026. Court docs Racial Justice Act and Habeas 2255 breakdown. We gonna break it down, man. And I'm not finna go through the governments. I do that in the morning. You know what I'm saying? When I wake up, I do that for y'all. For those that do want to hear the government's position, it was a weak argument. Raider Q, Big Messy Moore, what up? Triple OG, Double OG, Megan Davis, salute y'all up late. Lou from the Lou, Damu Kiwe Nation, Dupes, Yael, Red Heart, Blue Heart, Active Chucks, Messy Moore, 2-1, Raider Q. We in this beat, fetus. Hey, la, Monte. You know what I'm saying? Hey, la, Monte. So y'all know we got the character. I ain't gonna make y'all wait. It's a whole lot anyway. I want to get through this. I definitely want to get through this ASAP. Okay. So this one is the final Suge Knight appeal. Is 43 pages, right? And we're going to dive through it. This document, I want to make sure that this is the one I want to read, because I don't want to read the other one. Oh, yeah, here it goes. So we own it. Bang that like button, man. You know what I'm saying? Y'all know we got the content. You know what I'm saying? So this one is waiting for the courts right now. And it's really enlightening. Raider Q, man, hit that like button, right? Urban Max TV, what up? Dude, Sims to Don. Laugh out loud. Love from Louisville, Kentucky. Man, I never been to Louisville, man, and I want to go, right? I done seen too much going on in the Lou, you know what I'm saying, in Kentucky, man. I'm trying to see what that thing's about. But especially the Kentucky Derby, but I gotta get my bread up, you know what I'm saying? I gotta get my bread up before I get to attending that. So on the table of contents, you see California court rules. This is just attorney Jasmine Mines put this together, advocating on behalf of Suge Knight, the death row founder, mogul, former CEO. Introduction, statements of the case, governing legal standards, the Racial Justice Act. I was just learning about the the Racial Justice Act. When I read this, I was asleep on it. It passed, I think, in 2024. 4 legal pathways to show a RJA violation, types of evidence and burden of proof, arguments, reply to respondents' erroneous assertion that petition fails to state a prima facie case for relief under the Racial Justice Act. And then, so the conclusion will be the sum of it. There goes the table of authorities, and the case is cited in there. Look, one of the first cases, Batson versus Kentucky, 1986, United States Supreme Court. So, you know what I'm saying? You see, I told you, I'm trying to see what that Kentucky about the 6th Amendment and 14th Amendment, and then the statutes are listed right there, court rules. You know what I'm saying? So, introduction, let's hit that like button, man. The good people is up in here, man. The good people is up in here. Urban Max, Lou from the Lou. The LA shot caller when Suge gets out, CS2 back is moving to Mississippi. They said he already moved to Utah. Can't confirm it, but he done moved Birmingham, Alabama in the check-in. Hey, man, my homie Curtis Lopez. Oh, there go Castro right there. Talk about Alabama. Curtis Castro Lopez. Whoop, tapping in. Salute. Shout out to Birmingham and Mobile, Alabama. Free Suge, that's a fact. Miss Lisa, what up? We getting to this content. Suge finna get up out of here, so let's go. Tony Farley, salute. So this case places respondent in an unenviable position of defending the conduct of a shamefully racist prosecutor from the Los Angeles County District Attorney's Office. Deputy District Attorney Lawrence Longo, a malicious prosecutor who was later fired by the District Attorney's Office and disciplined by the California State Bar for creating the appearance of impropriety and making unauthorized promises in a 1992 criminal matter involving petitioner music mogul Marion Suge Knight Jr., Mr. Knight. The conduct respondent seeks to excuse includes Longo's references to Mr. Knight and others associated with Death Row Records as thugs, as niggers, and as that motherfucker should. Language that constitutes clear violations of the Racial Justice Act. Ooh, the cold thing about it, you got the DA in the office testifying to this. He wrote about it in the book. Yet respondent does attempt to defend the indefensible. It does so by exhibiting a profound misunderstanding of newly amended Penal Code subsection 7451, and by inviting this court to hold that a prosecutor may use the word nigger in the course of prosecutorial decision-making and influence without consequence, so long as the slur is directed at one black man rather than another. Respondent further advances this argument by, when they say the respondent, that's the government, right? The respondent further advances this argument by incorrectly asserting that calling a black defendant a thug is race neutral, and by invoking unrelated prosecutions of black public figures, including the internationally known entertainer Snoop Dogg, as if racial bias can be neutralized through racial substitution. In doing so, respondent's response itself violates Penal Code Section 745. Respondent improperly invokes the sealed prosecution of another black man, Calvis Brodus, also known as Snoop Dogg, who is not the petitioner, not a witness, not a comparator, and not legally relevant to any issue before this court. That prosecution resulted in a not guilty verdict and is sealed. Nonetheless, respondent resurrected it to contextualize, normalize, or diminish the force of explicit racial slurs used by a prosecutor in decision-making connected to Mr. Knight. This is not zealous advocacy. It is racialized reasoning. Section 745 was enacted to prohibit exactly this practice. The statute was designed to eradicate both explicit and systemic racial bias, including efforts to excuse discriminatory conduct by invoking the criminal history, alleged conduct, or past prosecution of other Black individuals. To an objective observer, referencing a sealed acquittal of a Black public figure serves no legitimate legal purpose and operates solely as an appeal to racial association. The statute does not permit respondent to import the prosecution of another Black man, particularly one who was found not guilty, to minimize or justify racial bias affecting Mr. Knight. By injecting a sealed case into his response, respondent repeated the very misconduct the act was enacted to eliminate, transforming his filing from a defense of past discrimination into a present and ongoing violation of Penal Code Section 745. Because respondent invites the court to assume the truth of the conduct and disputes only its legal consequences, no factual development remains to be undertaken. So basically, she on some shit like, well, look, since y'all not denying whether or not the truth of the matter, whether this was said, then your only dispute is have to let Suge Knight out because you violated this discrimination act that California passed, right? So this posture squarely implicates Penal Code Section 745, subdivisions A and H, which require courts to determine whether the conduct alleged is, if true, falls within the statute's prohibitions, rather than deferring enforcement through further proceedings. The statements of the case. We finna open up this water. Let's see who up in here. Y'all bang that like button, man. They got him. Trust me, he got him, bro. You know what I'm saying? Yeah, Raider Q. Man, Suge went through. We gonna go through some old content too. When I've been going viral now for like 4 years. Well, even before that, 15 years. Damn, I didn't know. Going viral is kind of like just a thing for me. You know what I'm saying? Y'all hit that like button. Help me go viral on this one. Let's get the good people up in here. You know what I'm saying? And said we got a clean Cuban Rob and the other two security too for Whack to tap out working for a fake lion punk. Urban Max, do you think Suge did right by wrapping all his cases up in that 28-year plea? I think he had a good shot of beating the murder case at trial, but I guess he was scared of getting that third strike. Nah, what it was, I talked to him about it. They weren't allowing him to get his own attorney. The fix was in. I thought he would have beat that too. It was obvious self-defense. You know what I'm saying? So, okay, let's get to it. So the statements of the case. Petitioner incorporates by reference the statement of the case set forth at pages 5 and 6 of the petition for writ of habeas corpus filed by Mr. Knight on September 18, 2025, and accepts as true the statement of the case set forth in the informal response filed by respondent January 16, 2025 at pages 7 through 9. Governing legal standards. The Racial Justice Act. So here is the legislative law of the Racial Justice Act, or known RJA. As our Supreme Court has recognized, racial bias is a familiar and recurring evil that, if left unaddressed, would risk systemic injury to the administration of justice. And they cite Pena Rodriguez versus Colorado, a 2017 U.S. Supreme Court case. The RJA, particularly subsection 745A1 and 2 took effect on January 1st, 2021. See, I thought it was 2024, but it was 2021. The legislature declared its intent to eliminate racial bias and to provide remedies that will eliminate racially discriminatory practices. People versus Wilson. The RJA seeks to eliminate both explicit and implicit racial bias, and to do so both prospectively and retroactively. Retroactively means this is applicable not just to cases once the legislation went into effect, but any cases that preceded it. You know what I'm saying? Meaning people who got cases 30 years ago, this is applicable to their cases if they face this kind of discrimination, right? The statute directs all parties in the criminal justice system to look through old cases and provide a remedy for any case in which racial bias, implicit or explicit, played a part, whether intentional or not. The duty to confront racial animus in the justice system is not the legislatures alone, but applies equally to prosecutors, defense counsel, and courts. The statute has now been amended 3 times, based first on the issue of retroactivity. So I guess the DAs do not want to let them brothers out of jail. So they was arguing that it wasn't retroactive. But Assembly Bill 256 clarified that it was retroactive. And most recently on what California Supreme Court Justice Goodwin Liu described as the silent evisceration of the act in Assembly Bill 1071, AB 1071, effective January 1st, 2026, the legislatures clarified that the less stringent prima facie standard of Section 745 subdivision H2 applies to both pre and post judgment claims, and stated that the dissenting statement in Henry Mendoza 2024 accurately articulates the legislature's intent in passing the RJA and concern about its silent evisceration. These findings illustrate some of the ways in which the courts misconstrue the statute to apply procedural barriers or otherwise impose impediments to relief, discordant with the legislative intent of the RJA, and improperly insulate convictions and sentences tainted by racial bias. That's Assembly Bill number 1071. Accordingly, contrary to respondents' arguments, and unlike traditional legislative history materials, these legislative findings are entitled to considerable weight because they are voted upon by the entire legislative body, enrolled and signed by the governor. Applied here, the statute requires courts to confront, not contextualize or excuse, a prosecutor's use of explicit racial slurs during plea negotiations tied to the petitioner's case. These findings are directly relevant at the prima facie stage, where the court's task is limited to determining whether the facts alleged, if true, trigger the statute's protections, not whether relief is ultimately warranted. B4, 4 legal pathways to show an RJA violation. To establish a violation of the Racial Justice Act, a claimant must prove one of 4 statutory grounds by a preponderance of evidence, i.e., more likely than none, basically a 51% to 49% chance, more likely than none, right? That's the standard that they have to prove it. The first 2 of which are most relevant here. 1, bias or animus by participants in the case. The judge, prosecutor, defense counsel, law enforcement officer, expert witness, or juror exhibited bias or animosity towards the defendant because of race, ethnicity, or national origin. And 2, use of racially discriminatory language during the trial proceedings. One of the listed participants used racially discriminatory language or otherwise show bias or animus toward the defendant based on protected characteristics, even if not intentional. Here, by calling Mr. Knight and Mr. Lee a nigger and referring to Mr. Knight as a thug, Longo exhibited an unlawful racial bias and prejudice, while his calling Mr. Knight a motherfucker displayed an animosity towards Mr. Knight and inappropriate anger, expressly recognizing that racial epithets, including the word nigger, are classic indicators of racial bias and prejudice. People versus Johnson, 1989. Acknowledging that the use of the word nigger is racially derogatory and inflammatory. Each of these pathways independently satisfies the statute. Proof of any one is sufficient to establish a violation and trigger relief. Accordingly, the failure to establish one pathway does not defeat a prima facie showing where another statutory ground is adequately alleged. In People versus Bowden, 2002, the California Supreme Court again acknowledged that racial epithets, including nigger, are highly offensive and prejudicial, noting that such language can demonstrate bias when used in a criminal process. And the court has consistently treated the phrase criminal process as encompassing the entire continuum of a criminal case, from investigation through plea negotiations to final disposition and post-conviction proceedings. People versus Superior Court. Here, that process includes the years-long pre-plea and plea negotiation process that occurred between Mr. Knight, his attorneys, David Canner, piece of shit, and Howard Price, and Deputy District Attorney Lawrence Longo, with the final disposition being approved by Assistant District Attorney Frank Sunstead. Are we gonna get back to this? Let me wet my whistle. Y'all bang that like button, man. Bang that like button. You know what I'm saying? It's nasty work. This is nasty work. So they called Suge a motherfucker and his boy a nigger in the same sentence. His boy, I believe, was the bodyguard for Snoop Dogg in the murder case that Snoop Dogg had beat. So they were bringing up this case. Snoop Dogg beat that case, and the case was sealed once he beat the case. But the DA ends up, well, we'll get to it right now. I wet my whistle. Let's get back to it. Types of evidence and burden of proof. In order to establish a prima facie showing under the provisions of the RJA, a claimant must produce facts that, if true, suggest a substantial likelihood that an RJA violation occurred. This threshold triggers further proceedings. At this stage, the court may not disbelieve, discount, or weigh the credibility of the allegation. This framework necessarily assumes the truth of the allegations for screening purposes, precisely. So courts do not short-circuit enforcement by recharacterizing legal questions on the merits. The claimant must ultimately show by preponderance of the evidence that one of the statutory violations occurred. This is a lower standard than beyond a reasonable doubt and is designed to allow both direct and indirect evidence of bias. In regards to permissible evidence, the statute, as amended through related RJA reforms and amendments, allows a wide range of evidence, including but not limited to witness testimony and trustworthy hearsay relevant to bias. Here, Review of the petition for writ of habeas corpus litigated by petitioner and proprietary persona while incarcerated until counsel was retained for this reply establishes that Mr. Knight did not rely solely on the excerpts from McKinley Malik Lee's book in arguing that Longo repeatedly made racist comments, but also clearly stated that at a hearing on the motion, Will attested to racial slurs directed at him by Longo and will further call as a witness McKinley Malik Lee. Based on these statements, counsel from petitioner has obtained sworn declaration from both Marion Hugh Knight and McKinley Malik Lee, Exhibit 2, that established contemporaneous accounts of Longo's repeated use of the words racially derogatory words, nigger and thug. D, ensuring access to evidence needed to support RJA claims for a fairer process. This court order responded to file an informal response addressing whether the facts set forth in the book excerpt may constitute facts, establishing a prima facie case for relief under the RJA. In its introduction, respondent alleges that the factual basis for the RJA claim is an excerpt from a book that was written by petitioner's associate. And then it shows you the respondents where they did it on page 7. This claim is only partially accurate, as Mr. Knight's in pro se petition for writ of habeas corpus clearly states in its own introduction that Longo made racist comments to Mr. Knight personally in the presence of Mr. Knight's attorney, David Canner. These overtly racist statements made by Deputy District Attorney Lawrence Longo to criminal defendant McKinley Malik Lee and referencing petitioner as a motherfucker, along with repeatedly referring to petitioner as a thug in the presence of petitioner and his attorneys throughout the plea negotiation process in this case, are part and parcel of one of the most egregious violations of petitioner's rights to a race-neutral trial imaginable. Petition in page 2. Mr. Knight went on to address the racist comments made by Longo by arguing accordingly. Petitioner moves this court to vacate the 1995 plea and at a hearing on the motion will attest to racial slurs directed at him by Longo and will further call as a witness McKinley Malik Lee, who has publicly stated that Longo sought to indict him, not in the pursuit of justice, but because he was alleged to be connected to the petitioner. Of course I'm going to prosecute his ass. He's with that motherfucking Suge. Based on these issues as presented and in preparation of a reply, counsel for Mr. Knight has obtained sworn declarations from both Mr. Knight and Mr. Lee as provided for by our legislature in the recent amendments made to the RJA and AB 1071, i.e., mandating that reviewing courts allow the newly retained counsel to supplement the record in order to better articulate the claim. Specifically, AB 1071 and the RJA provides that if a petitioner originally filed pro se, the court must permit newly appointed counsel to request additional disclosure of evidence as specified in the RJA and to amend the petition prior to the court taking further actions. If the petitioner has a habeas corpus petition pending in state court, but it has not yet been decided, the petitioner may amend the existing petition with a claim that the petitioner's conviction or sentence was sought, obtained, or imposed in violation of subdivision A of section 745 Penal Code subsection 1471 D1. This procedural posture confirms that the court is not being asked to consider new theories, but the same claim now properly supported and clarified by counsel. E, the court's role at this stage. Assembly Bill 1071 makes unmistakably clear that at the prima facie stage of Racial Justice Act claim, courts must accept the petitioner's factual allegations as true, including allegations that the prosecutor used explicit racial slurs during the proceedings. The California Supreme Court has confirmed that the RJA's pleading standard is intentionally minimal and forbids courts from rejecting allegations based on disbelief, lack of corroboration, or perceived implausibility. Trial courts may not weigh evidence or assess credibility when determining whether a prima facie case has been stated under subsection 745, and that's out of the case People versus Finley 2024. They're citing that, right? The respondent does not submit sworn evidence disputing that the statement occurred, and instead invites this court to assume the conduct occurred and resolve only its legal significance under Penal Code Section 745. AB 1071 was enacted precisely to abrogate judicial gatekeeping that screened out RJA claims and to ensure that allegations of overt racism, such as the prosecutor's use of racial epithets, are tested through adversarial proof, not summary dismissal. Where, as here, a petitioner alleges that a prosecutor employed racial slurs, the statute compels the court to proceed to the next stage of review. A contrary ruling is not a discretionary call, but a direct violation of Section 745 as amended, and therefore reversible error. See Young versus Superior Court, Solano County, 2022. So we finna get into the argument. You know what I'm saying? Y'all just gotta let me get a little bit of water, man. Bang that like button. It's late. Y'all could be anywhere on planet Earth, but y'all right here with me, finding out how Suge finna get out of jail. I would be ready to bet that he got out if I believed in the judicial system, but I learned to expect the unexpected when you're dealing with these devils, man. You know what I'm saying? So, the way y'all can't hear me, respect to the room. Raider Q marked out. What up, bro? Steffi Weffy, Deuce, you know we hurting down here in Texas. Rest in peace, DJ Michael Watts of Swisher House, close friends of mine. Yeah, I just talked to you about that, and then I see the thing that he passing. Let's go ahead and give a quick 5 seconds of silence for Michael Watts, 2000. Condolences to his family, his friends, and the whole Swisher House family. Shout out to Texas, man. You know what I'm saying? I was supposed to start it off with that. My bad. You know what I'm saying? I was so discombobulated. I just finished eating. You know what I'm saying? Renegade Duchess, salute. Free Big U until it's back, or free Simon until it's backwards, a.k.a. Big Suge. Yes, yeah, we sorry about your loss, man. Renegade Duchess, what up? Lou from the Lou. Dominique Mayweather. This racist system so dirty they do anything to get rid of us and still talk shit about us after we gone. That's crazy, bro. You know what I'm saying? Jerome King, free Big Suge, a.k.a. Simon, man. Free Big Suge. We got a video for y'all, too. There go DJ Michael, 5,000 watts, Swisher House, man. H-Town legend. That's a fact, but not just H-Town. You know, I was just telling Steffi Weffy when I seen the picture with her and him, I was like, man, you got to link me up with him. Michael Watts was, when it came to the independent distribution game, was the plug. Like, the Texas artist was able to get so much money independently because they were self-sufficient. And Michael Watts was at the top of that ecosystem, right? So Ice Cube had dropped, I think it was Smile Now, Cry Later, independently through his record label. and he had Michael Watts handle the distribution. That man went gold, a gold record, independently. So just say $7, not even $10, $7 times 500,000, 3.5 million record. I mean, $5 million off that record. That's legendary, bro. Chance for parole ain't until 2034. Yeah, so it's Dude's voice, bang that like button, and Dude's voice, bang that like button. G-Max, damn, imagine if Suge and Big U is free on these streets at the same time. It would be a good look for the city of Bampton and Crenshaw, right? Man, it'd be a good look for the West Coast. And it'd be, hey, them out-of-town cats coming out here would be having it hard because all that sweet shit, see, everybody wanted to be the get-along gang and everything sweet. You just can't come on my block and get money and not include us in the play. That's all I'm saying. You know what I'm saying? So the argument, the reply to respondent's erroneous assertion that the petition fails to state a prima facie case for relief under the Racial Justice Act. This court orders directed the respondent to address the question of whether an excerpt from a book that describes the use of racially based language by the assistant DA in a conversation about the petitioner's case may constitute facts that, if true, establish that there is a substantial likelihood that a violation of Penal Code Section 745, Subdivision A occurred for purposes of making a prima facie showing under the Racial Justice Act. Respondent addresses this court's question by alleging that the excerpt is inadmissible hearsay, or in the alternative, if the book excerpt is admissible, the violation was harmless beyond a reasonable doubt. And then that's page 15 in the respondent's reply. That's crazy. They're trying to say that even if it was true, and even if the hearsay rules mean that statement from the book that proves that, or that shows and contests that this was mentioned in 2001, that they called him a nigger and a motherfucker, that the DA is arguing, well, even if you do admit it and the admission of that into the record, it would still be a harmless a violation beyond a reasonable doubt. Mr. Knight, the human being whose life and liberty the respondent now characterizes as a harmless casualty of its own disgraceful racial animus, respectfully disagree. The respondent's harmless error argument fails as a matter of law because it disregards the role of the prosecutor, whose bias is documented in the record. Lawrence Longo was the assigned line prosecutor during the charging and plea negotiation phase, exercised prosecutorial authority over the disposition, and remained a prosecutorial actor connected to the case until his removal in 1996. The respondent's attempt to isolate the plea's final approval to another prosecutor does not sever the influence of Longo's conduct on charging posture, negotiation strategy, or case valuation. Moreover, the subsequent termination of Longo by the DA's office and discipline by the state bar for misconduct in this very case underscore that his actions were not peripheral or inconsequential. How you gonna say it was a harmless error, but this motherfucker got suspended from the bar, he got kicked out of the DA office, but when it comes to Suge Knight's life, it was a harmless error. It's nasty work, bro. The respondent identifies no evidentiary basis on which the court can conclude beyond a reasonable doubt that this bias had no effect on the judgment. On this record, the respondent cannot meet his burden to prove beyond a reasonable doubt that racial bias played no role in the judgment. Penal Code Section 745 does not permit courts to presume harmlessness where prosecutorial decision-making was infected by explicit racial animus. Mr. Knight replied specifically and generally to respondents' informal response. Mr. Knight specifically and generally denies each and every allegation made in the informal response that is in contravention of the claims raised and allegations made in the petition. Mr. Knight does not waive any claim, legal contention, or factual assertion raised in the petition, even if such claim, legal contention, or assertion is not specifically addressed in this informal reply. Mr. Knight realleges and reaffirms each and every legal and factual claim, contention, allegation, and assertion raised in this petition. Mr. Knight fully incorporates in all exhibits submitted with the petition and as filed with this reply. Mr. Knight's analysis is set forth in two parts. Both components address the statutory inquiry before the courts by demonstrating that the facts alleged, if true, establish a substantial likelihood of a violation of Penal Code Section 745. And by responding to respondents' attempt to reframe that inquiry as one of admissibility or harmlessness rather than enforcement. The first refutes respondents' mischaracterizations of the record and selective parsing of isolated statements from multiple declarations submitted by Mr. Knight's attorneys and Deputy DA Longo as it pertains to relevant background and history of the case at issue. The second component of Mr. Knight's analysis specifically and generally contests respondents' argument on the merits of Mr. Knight's claims and inappropriate invoking of unrelated prosecutions of other Black public figures, which transforms the response from a defense of past discrimination into a present and ongoing violation of Penal Code subsection 745. Relevant factual background. So this is what this case was about, right? So they hit Suge with the 3 strikes. So he got doubled up. He would have had, I think, 14 years, right? But I believe under the 3 strike law, that second strike makes you have to get doubled up, right? I believe that's what it was. But don't quote me on that part. I'm just trying to remember. But we're going to get into this original case because the basis of this is I really hate Spirit One. I really hate that I'm late to this party. Wes. Shout out to the Damu Kiwe conversations. And to the chat. Best chat of all chats. That's a fact. And the Cash App is on the bottom line for all Cash Apps. Please make sure that you also send me your address. We'll be sending y'all out a box of United color wraps for the next 10 Cash Apps on these lives. We'll get a box of United color wraps and a signed CD, my signature autographed CD, DUSE, Still I Live album, my first classic mixtape, datpiff.com. You know what I'm saying? It's no longer on DatPiff, but you will get the album cover, the actual commemorative to my first album with a box of color wraps, man. So Cash App, or Super Chat, but I would prefer the Cash App because YouTube go take some of that Super Chat. You know what I'm saying? But let's get back to it. Let me drink a little bit more water, man, and get to it. Mike B, what up, bro? In February of 1995, pursuant to a negotiated plea bargain and upon the advice of counsel, petitioner entered into a plea of no contest to 2 counts of assault with a firearm with attending firearm use allegations as to each count. Suge got cracking with that pistol. You know what I'm saying? In this case, he pled in 95, but I think he caught the case in 91 or 92. You know what I'm saying? But Suge wasn't just putting hands on it. He will get cracking. You know what I'm saying? This plea was in regards to a 1992 incident. See, 92. And was negotiated between Mr. Knight, his attorneys David Kenner and Howard Price, with attorney Johnny Cochran in advisory role. Rest in peace to the late, great legend, Johnny Cochran. South Central LA, stand up. One of our own, you know what I'm saying? Deputy District Attorney Lawrence Longo, and approved by Frank Sunstedt, a veteran prosecutor with 39-year career in Los Angeles County District Attorney's Office, ending around 2001, serving as a head deputy, assistant district attorney under Gil Garcetti, and supervisor of Central Branch Operation. Fuck Gil Garcetti and his motherfucking cronies. You know what I'm saying? Oh, yeah, man, we got it cracking. So, as part of the bargain, the trial court placed Mr. Knight on 5 years formal probation with the understanding that upon successful completion of probation, the convictions would be reduced to misdemeanors and not count as strikes under the 3 strikes law. So, excuse me. So these were supposed to be felony misdemeanor wobblers. He pleaded to the felony. Upon completion of his probation, they would be turned over into misdemeanors and wouldn't be strikeable offenses. If that's true, then he couldn't have been serving 28 years for the 3 strike law. In the informal response, respondent mischaracterizes the declarations of these parties as submitted in 1998 by alleging that Longo stated that he was not present during the plea negotiations in this case, and that petitioner's attorneys, David Kenner and Howard Price, corroborated Longo's account of the case history in their own declaration signed March 1998. This is not accurate. What Longo declared in 1998 after he was fired by LA County DA's office and disciplined by the state bar for his conduct in this case was that in 1995, I was not present at meetings regarding the disposition of this matter, which involved defense counsel and ADA Frank Sunstedt. And there goes petitioner's exhibit H on page 1. Longo never declared he was not a party to the numerous meetings between Mr. Knight and his attorneys prior to Sunstedt's approving the plea as negotiated. He declared that he wasn't present in 1995 when the meeting with Sunstedt occurred. Likewise, in their respective declarations, which were essentially duplicative, attorneys David Kenner and Howard Price did not corroborate Longo's account, as both declarations state that I participated in negotiations with the LADA's office concerning the disposition in this matter, which included a meeting with Deputy District Attorney Frank Sunstedt. Petitions Exhibit I through J. Nowhere in these declarations does either of Mr. Knight's attorneys declare that Longo was not a party that was negotiated with in the prosecution. This parsing of excerpts from these declarations is an attempt to portray racist prosecutor Longo as a passive non-participant in the plea negotiations in what was a high-profile 1992 assault allegation. Yet Longo's conduct in personally negotiating the plea was the very reason he was served dismissal notices not once but twice. In an article from the LA Times dated March 22, 1997, the LA County DA's office confirmed that after serving a dismissal notice concluding that Longo should be fired for his handling of the 1992 assault case involving Mr. Knight, a second dismissal notice was served on Longo by the DA's office that included two new allegations: that Longo made unauthorized promises to Knight as part of a controversial 1995 plea bargain in the assault case, and that Longo's conduct leading up to the plea bargain caused the loss of public confidence in the office. See Exhibit 3, the LA Times Archive, March 22nd, 1997. That is the correct record upon which Mr. Knight presented his claims in pro se with this court. And public confidence in the Los Angeles County DA's office can be restored by this court calling the jailer to account by ordering Mr. Knight's conviction and sentence in this case vacated. This history matters because it situates the racial language within active prosecutorial authority, not isolated misconduct. B, the excerpt from McKinley Malik Lee's book is admissible. AB 1071 and Penal Code subsection 745 permit consideration of non-traditional evidence, including narrative accounts, to establish a prima facie RGA violation. Courts construing the amended statute have emphasized that legislature intentionally lowered the evidentiary threshold to prevent early dismissal of credible claims of racial bias. Penal Code Section 745 expressly authorizes courts to consider narrative accounts, out-of-court statements, and other non-traditional evidence for the limited purposes of determining whether a substantial likelihood of racial bias exists, without requiring compliance with trial admissibility rules. In People v. Harris, 2023, the Court of Appeal held that AB 1071 materially altered the pleading and proof requirements under Section 745 and rejected the notion that a petitioner must present admissible trial evidence at the prima facie stage. Harris confirms that courts may not impose extra statutory evidentiary hurdles, including demands for sworn declarations or formal authentication before ordering a hearing. At the prima facie stage, the question is not whether the evidence would ultimately be admissible at trial, but whether the facts alleged, if true, fall within the Conduct Penal Code Section 745 prohibits. Likewise, in People v. LaShawn, 2024, the court explained that credibility determinations and evidentiary weighing are improper at the initial RJA stage, emphasizing that 745 requires only a showing that, if the facts alleged are true, relief may be warranted. Summary denial based on perceived evidentiary defects revives the very procedural barriers AB 1071 was enacted to dismantle. Accepting the narrative account as true for screening purposes is not optional. It is the analytical framework the legislature mandated to prevent racial bias claims from being dismissed through credibility assessments or evidentiary gatekeeping. Here, the book excerpt from Mr. Lee recounting the prosecutor calling him a nigger and referring to Mr. Knight as a thug and a motherfucker is direct evidence of racial animus and falls squarely within Section 745A1 and A2. Specifically, the excerpt alleges the use of an explicit racial slur by a prosecutorial actor while discussing charging decisions, conduct that Penal Code Section 745A1 defines as racially discriminatory language that explicitly appeals to racial bias. The excerpt further alleges that prosecutorial hostility and decision-making were expressly tied to racialized stereotypes and perceived group affiliation, conduct independently prohibited by Section 745A2, whether or not purposeful. Courts have long recognized that racial slurs by prosecutors are uniquely probative of unconstitutional bias. See People versus Rivera. Racist epithets by state actors are powerful evidence of discriminatory intent. Federal courts are in accord. In Miller L. versus Drek, 2005, 545 U.S. Supreme Court, the United States Supreme Court held that expressions of racial bias by prosecutorial actors, whether formal or informal, are highly probative and need not be sanitized by procedural formalism. The RJA codifies this principle and expands it. Rather than contesting the account through competing sworn evidence, the respondent invites the court to assume the statements occurred and argues that even if true, the conduct is legally irrelevant under Penal Code Section 745. For purposes of the prima facie inquiry, that invitation is dispositive of the evidentiary question because the statute asks only whether the alleged conduct assumed true falls within its prohibition. That posture presents a purely legal question at the prima facie stage, whether sworn or narrative allegations of explicit racial language by a prosecutorial actor taken as true fall within the conduct the statute prohibits. Under AB 1071 and controlling authority, they do. No additional authentication, corroboration, or evidentiary development is required for the court to determine that Section 745 has been implicated. Where the respondent asks the court to proceed on the assumption that the conduct occurred, the statute forecloses dismissal based on evidentiary gatekeeping or credibility concerns. C. Racial slurs made by the prosecutor during case-related meetings occurred during the proceedings under Penal Code Section 745 as amended by Assembly Bill 1071. Let's see what they talking about in the chat, man. What they talking about in the chat. Hit that like button. The chat's where it's at. Shout out to the Blue Rich Mob, always on their job. Drew V. Go time. Mike Braxton, what up, bro? Shit, just chilling, chat. Hit your brimming and hit that like button, man. Hit that like button and hit your brimming. Hit that like button for us, food peoples. Salute to the people listening in the cut, man. Drew Sims done. You already know, Drew. Drew V. Let me make sure I ain't got no cash app from nobody too. Because I man, listen, man, if y'all send a cash app, make sure, yep, I got a cash app. See what I mean? See what I mean? Let me see. Oh, yeah, that's Drew V. A little something for the work you put in, bro. Drew V. So I got that. I hit that hard. Please DM me your a mailing address, a P.O. box, and some. I'm gonna send you some if you smoke, or if just giving somebody a smoke, I'm gonna send you a box of United Color Wraps, and I'm gonna send you a autograph verse of copy of my original CD, a commemorative item. You know what I'm saying? We coming with the commemorative merch too, so the hit your brimming when we hit MTV internationally. You know what I'm saying? An independent record went international. Italy, Spain, you know, Germany. You know what I'm saying? You know, you gotta commemorate those things. You know what I'm saying? I was there. You know what I'm saying? I'm sweating this Golden State game. Damn, DraftKings and FanDuel got me, man. But you gonna hit, Lou. If you sweating it, that means you're close to hitting. Good luck on hitting, bro. You know what I'm saying? You know what I'm saying? Winifred, he's not getting out. Oh, that sounds like pork butt. Let's see if pork butt is in my chat right now. Let's find out if that's pork butt. Degrees fucking with your mental. Pork butt, pork butt. Watch this. Oh, he gonna be mad, man. Hold on. Veggie wrong, veggie wrong, veggie wrong. I know that's you, Veggie. Winifred Williams. You know what I'm saying? He's not getting out. It looked like he is, bro. It's very, very strong case and a great argument. Shout out to his attorney. Hold on. Reggie Wright Jr. Let's see if Reggie answered my call. Hold on. Woo. $17.98. Hey, what up? Pork butt. Wake your ass up, man.
I don't sleep like your ass. Because you on your way with your Mexican wife and fucking clean some goddamn buildings. Don't be calling me, nigga.
No, I'm live right now. We ain't
no motherfucking buildings.
Hey, we ain't cleaning no buildings, but listen, I ain't knocking nobody who do it. Somebody got to do it. Hey, as long as you ain't selling your ass and compromising your integrity, get it how you live.
Whatever. Say that bullshit. Motherfuckers sit on the internet all day talking shit about people. Don't need to be mopping no goddamn floors.
Hey, listen.
Better hustle than that.
Yeah, if you right about that, I got a better hustle than that. But look, check this out. So you know, old Simon, Simon's finna be coming home.
He probably gonna get out because he got blind.
Nah, he finna get out because that first case, that motherfucking that the firearm assault with the firearm, the 2 counts of assault with a firearm. You said that if he keep talking shit, you was gonna keep him in jail and he'll never get out.
Has he said anything since I said that?
Man, listen.
Has he said any motherfucking thing since I
said that? Listen, man. That nigga ain't worried about you. He
off of YouTube since I said
man, he getting his bag, nigga. He focused on his bag.
Fucking with Damon Thomas. Damon Thomas is the biggest comment on the thing. He think Damon Thomas.
No, the biggest comment on the biggest comment is you and CS2 back.
But we ain't mopping motherfucking floors that night.
Hey, listen, man.
Matter of fact, what happened to my fucking tamales? Maria supposed to make it for me.
Maria ain't making you no motherfucking tamales. Hey, but anyway, so what's up with you see what I seen you was on something today. What you was talking shit about today, man? Oh, you was talking about Snoop Dogg and Death Row, how they running it right now, right? Oh yeah, well I'm gonna see. Oh, it's old, yeah. But see, y'all ain't got no content.
Over there about 3-4 months. I just drop old shit and get the amount of views and still be able to live.
Man, you don't get no motherfucking amount of views. Your views are down as a motherfucker. Shout out to the Bahamas.
I bet you they got 15,000. I bet you they averaging over 15,000 an episode a day.
Man, you got caught buying. You got caught buying views. Fuck you mean? You think we didn't know? Man, y'all, you got.
He already sold his portion of the channel.
No, this was before. This before he sold that. Stop trying to insult my intelligence. He got caught. Y'all got caught doing that before he sold his 50% share.
YouTube live because y'all, you motherfuckers only get 2,000 views, but y'all want to lie and say shit like that.
Hey, listen, Reggie, there's not a YouTube channel on YouTube that has more credibility than us. So why would you keep calling me a liar?
In your opinion.
You know how you can have, how you would have, hey, you know how you would get more credit?
On your channel, listen to your shit.
Do you know how you would get more credibility, Reggie? First, you know how your channel will have more credibility if you admitted if you admitted publicly that you always gonna bleed blue because you a cop at heart. If you admit,
I have never talked bad about my past. I love my past.
So you a cop at heart.
I don't have a problem with law enforcement.
I know you don't.
I fuck with niggas that I grew up with too.
Man, so you playing both sides. You the middleman.
Nah, I ain't never did nothing. That one nigga that I ever grew up with could never say I gave him heads up or did something like that. I might have gave him some like advice or something like that, or gave him a break. But I ain't never jeopardized none of my cop friends.
Well, the other way,
I play both sides of the fence.
The other way you can get some real credibility is expose your rat ass son CS2 back.
I don't know why you got a hard on for that nigga.
Man, cause that bitch ass nigga called me a rat, nigga.
You know, he passed that, man. Get off that.
He ain't past that.
I told everybody, the one thing that you did when you got your jaw busted up, you fell off the fucking bed. So you ain't no rat. You just from that nigga.
Hey, check this out, Reg. Is you gonna keep up?
You didn't tell the guard that you fell off your bunk.
Just in case the dude that I stabbed.
Wait a minute. Hold on. You didn't tell the guard that.
I told them, no, I told the medical that I fell off the thing. Yeah. Fuck, you mean I told the guard? I told medical. Yeah, nah, nigga, medical is different. The COs work for the CDCR. The medical, them motherfuckers. It's freestyle.
When she was wiring up your jaw.
My jaw wasn't wired, it wasn't broke, nigga. Hey, but you seen that motherfucking paperwork? I pushed that knife in that nigga neck, though. Yeah, motherfucker. But all right, Reg, man. Is you gonna expose CS2 back or not, man?
That's my homeboy.
Oh, well, if CS2 back your homeboy, we know you ain't gonna never expose him. Meanwhile, Philip, what's his name? The FBI agent, Philip, what you call it, is on your helmet right now. Man, that motherfucker exposed your ass, nigga.
He didn't know me when he saw me. He was like, "Is that you, Reggie? Yeah, is that you?"
Man, cause you had got sick. A lot of people couldn't tell it was you. Now you gained it all back. You look like Piece of the Hun from Spaceballs, nigga.
Yeah.
That nigga say it. Man, bye. Don't nobody want to hear about your dick. Hey, man, bye. Hey, he said CS2 back is his homeboy. We gonna get back to the content, man. But he said, Pork Butt said, now, if I'm understanding correctly, she asked that all his cases be thrown out because of derogatory statements. Yes, the initial case that he caught in 1992, which was assault with 2 counts of assault with a firearm. DUSE said that nigga was buying views. He was. Reggie showed him legs in that wheelchair. 500,000 views instantly. Cop at heart, dirty cop at heart. For real, Renegade Dutchess. I can't get over the fact that he answered the phone. Yeah, medical bitches brought that work. Pork butt, goddamn, that knife to the neck. Yeah, I was trying to hurt the dude, man. You know what I'm saying? And he kept it gangster. You know what I'm saying? He said I didn't have no weapon. You know what I'm saying? 16 stitches in his neck. You know what I'm saying? But let's get back to the content so we can get up out of here. So, bam. Racial slurs made by prosecutor during case-related meetings occurred during the proceedings under Penal Code Section 745 as amended by Assembly Bill 1071. The racial slurs uttered by the prosecutor during case-related meetings between Mr. Knight, his attorneys, and Longo, along with Longo's statements to Mr. Lee's attorney, calling Lee a nigger and stating that I'm going to prosecute his ass. He's with that motherfucking Suge occurred during the proceedings within the meaning of Penal Code subsection 745 as amended by Assembly Bill 1071. AB 1071 was enacted to broaden the Racial Justice Act and to close loopholes that had allowed racially biased conduct to evade review by being recast as informal or off-the-record activity. Public Safety Analysis of Assembly Bill 1071. The legislature expressly intended subsection 745 to be construed expansively so that discriminatory conduct occurred in the course of prosecutorial functions tied to the prosecution of a case is subject to judicial review, regardless of whether it appears in a courtroom transcript. The conduct described satisfied Penal Code Section 745A1 because it involves racially discriminatory language used by a prosecutor in the course of performing prosecutorial functions directly connected to the prosecution of Mr. Knight's case. It also independently satisfied Section 745A3, which prohibits reliance on racially biased narratives or associations in charging, plea negotiations, or sentencing-related decision-making. The statute does not require that such conduct occur in open court, be memorialized in a transcript, or be directed exclusively at the petitioner so long as it is connected to prosecutorial action in the case. The Senate Committee on Public Safety echoed this intent, emphasizing that racial bias most often manifests outside formal courtroom proceedings, during meetings with law enforcement, witnesses, or members of the prosecution team, and warning that limiting the statute to in-court statements would undermine the remedial purpose of the Racial Justice Act, as amended June 20th, 2023. The legislature therefore rejected any artificial distinction between formal courtroom appearances and the broader prosecutorial process by which criminal cases are investigated, charged, and litigated. This reading is compelled not only by legislative intent, but by constitutional principle. In Pena-Rodriguez versus Colorado, the U.S. Supreme Court held that racial bias infecting deliberative or decision-making processes cannot be insulated from judicial scrutiny merely because it occurs outside public view. The court recognized that racial animus presents a unique threat to the integrity and legitimacy of the justice system and must be addressed whenever it surfaces. AB 1071 codifies this principle within California law, construing during the proceedings to exclude case-related meetings would nullify the legislator's expressed intent, frustrate the remedial purpose of Section 745, and resurrect the very loophole AB 1071 was enacted to eliminate. Respondents' cramped interpretation would reduce the Racial Justice Act to a rule of courtroom decorum rather than the comprehensive safeguard against racial bias the legislator unmistakably intended. To hold otherwise would permit racial bias to evade review solely by occurring where it most often arises inside prosecutorial decision-making rather than inside a courtroom. Under this framework, the conduct alleged here falls squarely within the scope of Section 745 as amended, and no further factual development is required to reach that conclusion. The term thug is not race neutral. Respondents' insistence that the term thug is race neutral is not merely an evidentiary dispute. it is itself a violation of the Racial Justice Act under Penal Code Sections 745, Subdivision A1. Section 745 prohibits not only the use of racially coded language, but also the defense of such language through claims of neutrality that disregard its discriminatory meaning and effect. The statute prohibits both the original use of racially coded language and the later defense of that language through false claims of neutrality. By urging the court to treat thug as neutral, despite the legislature's express findings to the contrary, respondent repeats the very analytic error AB 1071 was enacted to correct. As an attorney in the case, the respondent's attempt to sanitize a descriptor that the legislature has explicitly codified as dehumanizing and othering is an exercise in the very racialized reasoning the act was designed to eradicate. By justifying the trial prosecutor's bias through dictionary definitions rather than the mandatory objective observer standard required by subdivision H4, respondent effectively seeks to obtain the continuation of a conviction on the basis of racialized proximity. This ongoing use of race-neutral justifications violates the remedial purposes of the act and mandates that the court vacate the conviction to fully vindicate the protections of the penal code. The appropriate remedy for such a violation is addressed below. At this stage, the issue is whether the statute has been triggered. Respondent attempts to minimize the remarks regarding Mr. Knight being a thug as race neutral, citing to Merriam-Webster Dictionary online for a definition of the word. Respondent would have been better served by actually citing to the RJA as amended by AB 1071, as our legislature found it necessary to provide courts explicit guidance on language that functions as coded racial epithets, specifically identifying thug as such, noting that courts have failed to find a prima facie showing of racial bias where participants in the prosecution or investigation use dehumanizing and othering language such as predator, monster, sociopath, terrorist, brute, thug, gangster. The amendment was intended to foreclose precisely this kind of post-hoc sanitization of racially loaded language and to ensure courts evaluate the term for its discriminatory meaning and effect, not its superficial neutrality. Courts have also repeatedly acknowledged that terms such as thug, when directed at Black men, function as racially coded language. See People versus Richardson, recognizing thug as a racially charged descriptor depending on context. When coupled with the explicit use of the word nigger, the racial meaning is unmistakable. Here, the term was not used to describe conduct, but to characterize the petitioner himself in the course of charging the plea-related decision-making, which is precisely where racialized language exerts its most corrosive effect. Though this reply is accompanied by declarations from Mr. Knight and Mr. Lee, nothing in Section 745 requires that evidence be presented through a declaration of sworn testimony at the pleading stage. To the contrary, People versus Harris Supra expressly rejected that requirement, holding that AB 1071 expanded the universe of evidence courts must consider and forbids courts from importing trial-level evidentiary rules into RJA screening. In sum, the book excerpt is admissible, sufficient to establish a prima facie RJA violation, and mandates that Mr. Knight's 1995 conviction and sentence be vacated. Any ruling excluding it on hearsay, authentication, or declaration grounds conflicts with AB 1071, Section plain language and controlling appellate authority. The term motherfucker is not race neutral. Wagstaff make clear that language must be evaluated in the context in which it is deployed, including surrounding statements and the speaker's demonstrated bias. People versus Wagstaff, 2025. Here the term was used contemporaneously with an explicit racial slur, and in the course of denigrating a black defendant and his associates while discussing prosecutorial action. To an objective observer, the use of motherfucker in this setting functions not as a neutral expletive, but as part of a stream of dehumanizing and hostile language directed at black men perceived as criminal and dangerous. When layered with explicit racial epithets and racialized descriptors such as thug, the term reinforces a narrative of contempt and othering that Penal Code Section 745 squarely prohibits. The racial meaning arises from its deployment as part of a unified racialized narrative by a prosecutor who simultaneously invoke explicit slurs and group-based criminal stereotypes. This language is racially discriminatory when used as part of a prosecutorial narrative explicitly grounded in racial animus. D. Respondent's use of Snoop Dogg's unrelated murder prosecution, for which he was acquitted and had his record seals, constitutes an independent violation of the Racial Justice Act. Respondent's conduct goes well beyond improper advocacy and constitutes an independent violation of the Racial Justice Act as amended by Assembly Bill 70. In opposing relief, respondent deliberately invoked Snoop Dogg's unrelated murder prosecution, a case that resulted in an acquittal and whose records were later ordered sealed in order to inject racialized innuendo into Mr. Knight's post-conviction proceedings. This tactic amounts to a calculated circumvention of sealing orders and a transparent effort to smuggle racial bias into judicial review where the law forbids it. That the reference prosecution resulted in an acquittal and sealing renders in its invocation not merely irrelevant, but affirmatively unlawful. California courts have long recognized that sealed records are treated as legally non-existent and may not be resurrected directly or indirectly to influence subsequent proceedings. Respondents' reliance on an acquitted, sealed prosecution involving a third party flouts these principles and undermines the very purpose of sealing orders to prevent prejudice, stigma, and misuse of legally null proceedings. AB 1071 expressly expanded Penal Code Section 745 to reach post-conviction proceedings and to prohibit the use of racially charged narratives, stereotypes, or associations that would not be invoked but for race, ethnicity, or perceived group affiliation. The courts construing the Racial Justice Act have emphasized that the statute targets not only explicit racial epithets, but also more subtle forms of racialized reasoning and narrative framing that distort the adjudicative process. The adjudicative process. I never heard adjudicative or adjudicate. I never heard adjudicative process. Okay. RJA is remedial and must be construed broadly to eradicate racial bias from criminal proceedings, recognizing the corrosive effect of racialized assumptions and associations on fairness and legitimacy of proceedings. By resurrecting a sealed prosecution involving another Black public figure, wholly unrelated factually, procedurally, or legally to Mr. Knight's case, the respondent relied on material that serves no evidentiary function other than to invite race-based inference. That approach mirrors precisely the form of racialized association, the legislature sought to eliminate attribution or guilt or dangerousness through race rather than admissible case-specific evidence. This is the very practice condemned in equal protection and biased jurisprudence. By decision makers to draw adverse conclusions from race or group identity rather than conduct. E. Respondent's conduct independently satisfies the elements of Penal Code Section 745. Penal Code Section 745 prohibits a prosecutor from using racially discriminatory language or racially coded narratives during any stage of a criminal proceeding, including post-conviction litigation. As amended by Assembly Bill 1071, the statute expressly reaches conduct that, to an objective observer, implicitly appeals to racial bias, including the use of racialized associations, stereotypes, or group-based narratives that would not be invoked but for race. Respondent's invocation of a sealed acquitted prosecution involving another Black public figure satisfies these elements. An objective observer would understand the reference not as neutral legal context, but as an effort to associate Mr. Knight with racialized notions of criminality, violence, or notoriety through proximity to another Black man's unrelated case. That association has no legitimate evidentiary purpose and operates solely as a racialized narrative device. Under the statute, neither intent nor outcome is required. The use of racially coded association itself in the course of prosecutorial advocacy constitutes a violation of subsection 745A2. This conduct independently violates Penal Code Section 745, regardless of any other racial language in the record. The violation is further compounded by respondents' conscious disregard of the sealing order itself. Sealed proceedings cannot lawfully be repurposed as rhetorical devices in post-conviction litigation, and their selective invocation here serves no legitimate evidentiary function. Instead, it operates solely to evoke racial prejudice and to distract from the merits of Mr. Knight's Racial Justice Act claim. Such conduct falls squarely within Penal Code Section 745A1 and A3, as amended by AB 1071 and independently mandates relief. Remedy: petitioner has established a violation of the Racial Justice Act, Penal Code subsection 745 subdivision A. As amended by Assembly Bill 1071, the statute requires immediate and effective relief once a violation is proven. The proper remedy here is vacatur of the judgment of conviction and sentence, not a remand for additional proceedings, by inviting this court to assume the truth of sworn evidence and resolve only whether the statute requires relief. The respondent removes any factual predicate for remand. Because the respondent invites the court to assume the conduct occurred in disputes only its legal consequences, there is no factual controversy for further proceedings to resolve. The respondent cannot simultaneously invite assumption of truth and demand further proceedings to test it. The question presented is one of statutory enforcement, not evidentiary development. Where the disagreement is legal rather than factual, remand does not advance accuracy or fairness. It postpones enforcement. Upon this court's finding that a violation of a Racial Justice Act has occurred, the court has direct and independent authority under Penal Code Section 745 subdivision E to vacate a conviction and sentence. That authority is not limited to trial courts. This court's jurisprudence reflects a consistent remedial principle where a legal or constitutional violation is established on the existing record and no further fact-finding is required. Immediate appellate relief is required, not a remand that merely delays correction of the error. The court has also repeatedly exercised this authority to vacate unlawful components of judgments and to correct prejudicial error without remand. Those cases embody a settled principle of this court's remedial jurisprudence. Once a violation is shown, the appellate court must provide effective relief rather than defer responsibility back to the trial court. A remand in this case would depart from that settled practice. The RJA violation has already been established. The record is complete, and the conviction and sentence were tainted by racial bias. Under these circumstances, a remand would serve no remedial purpose and would instead perpetuate the very harm Penal Code Section 745 and Assembly Bill 1071 were enacted to eliminate. A remand will also be prejudicial and, in practical effect, illusory. The events at issue occurred more than 3 decades ago. Some of the attorneys who participated in the original plea negotiations are now deceased, and others are of advanced age. Petitioner himself is approximately 60 years old and suffers from significant health impairments, including legal blindness. Further delay risks the permanent loss of remaining testimony and renders any future evidentiary proceeding unreliable in practice, even if theoretically available. In addition, ordering a remand in this case would also all but guarantee that the matter would languish in the lower courts. A remand would not merely postpone relief, it would effectively deny it. Racial Justice Act proceedings are resource intensive and require sustained participation by a single prosecuting authority. Whereas here, the legal issue is dispositive and no further fact-finding is required, returning the case for additional proceedings will predictably result in years of delay as a structural consequence of the process itself. The outcome is inconsistent with Assembly Bill 1071's directive that relief under Penal Code Section 745 be effective in practice, not merely theoretical. Assembly Bill 1071 reflects a legislative rejection of delay-based remedies and reinforces that Section 745E requires an effective remedy, one that actually cures the violation, consistent with this court's own remedial jurisprudence and the legislature's express intent. This court should not remand for further proceeding, but should vacate the conviction and sentence to fully vindicate the protections of the Racial Justice Act. The legislature amended Section 745 precisely to prevent racial bias claims from being deferred through procedural detours once the statutory threshold is met. Conclusion: for the foregoing reasons, this court should grant Mr. Knight's claim for relief under the Racial Justice Act and order his conviction and sentence vacated. There you go. Respectfully submitted. Jasmine Mines, ESQ, attorney for petitioner Marion Q. Knight. And there you go. There you go. Exhibit 1. You got exhibit, the declaration from Suge. We'll be posting this for y'all. Y'all can read that later. You know what I'm saying? That's Suge Declaration Exhibit 2. The declaration from McKinley Malik Lee. You know what I'm saying? And Exhibit 3. You know what I'm saying? Deputy DA Longo. This is the LA Times article. You know what I'm saying? And there you go. There you go. You know what I'm saying? There you go. Let's see what the good people talking about, man. Bang that like button. So let me make a poll. I should have already had a poll made for y'all. Pardon me, man. I started late. You know what I'm saying? And now we're gonna go ahead and make this poll. So CS2 back PC'd up and moved. He rolled his shit up in a little burrito. You know what I'm saying? He rolled his shit up in a little burrito. You know what I'm saying? Tell him you can't live here no more. They say he moved to Utah. You know what I'm saying? Witness protection in Utah. You know what I'm saying? So we're going to get this poll going. The poll is based upon this motion of the Racial Justice Act, based upon the Racial Justice Act and this argument that we just did, is Suge coming home. Based upon the RJA is Suge Knight coming home soon. Let's get that. Yes, no. Y'all let me know what y'all think. Simon. Oh, yeah. So he moved to Utah because he knew Suge was coming home soon. Reggie gonna run off too. I'm the motherfucking police. Reggie, the police. So we got a video for y'all. I know y'all, a lot of y'all don't know how long we've been doing this content. I do some of the greatest interviews, man. But this was an interview with D-Dog. In fact, at this time, I wasn't even beefing with CS2 back. So you're talking about maybe 4 years ago? Yeah, that's what it was. 4 years ago. You know what I'm saying? And everybody used to peddle this. Shout out to the Lionel B show. You know what I'm saying? Everybody used to be putting up my content, and I wasn't even putting my content on YouTube. I was just running content on Clubhouse. You know what I'm saying? Sometime I might put it on Spotify or something, but all of it going viral. So this was what, 70,000 views, right? And this was just this channel.
That he got some issues he want to air out, and he got
bracket? What's bracket?
What's bracket, big homie? I'm DUSE. Who's this? D-Dog?
Yeah, this D-Dog homie from NHP Inglewood.
You know what I'm saying? Wack just had pulled up, and he spoke on you. I wasn't here because I was holding the other room till the homie came back. You know what I'm saying? So you could set up what you had to do to get on this platform. But he gave a little background of you.
Yeah, so basically all that shit that nigga said, with 95% of it is bullshit. Okay? I'm gonna tell you like this. Where it start off, well, really I'm gonna just start from the beginning. You know, I played the movie straight out of Compton, and that's how I
Lou feeling loose, salute.
met Bone.
Right.
So
the Mormons go sacrifice what? Salute Aiden Phillip White. Let's go.
You know, being in that atmosphere, you know, it was a lot of, you know, side talk and sneak dissing on Suge Knight the whole movie while he was filming the movie. So long story short, it was a plot together to take Suge down.
Okay. And so there's a plot to take Suge down, right?
Yeah.
Niggas is talking dirty on his name and all of this type of shit, right?
Yeah, okay, from directors, actors, you know, and everything else in between.
So really the industry, you talking about the powers that be in hip hop.
Yeah. Yeah.
Why?
Pretty much.
Okay. So that brings to name some faces and powerful people, that some of the most powerfulest people in the industry, right?
Yeah, yeah, very big. Billionaires.
All right. Now keep going. This is your flow, man. Go ahead and tell your story.
Well, what it was is this, right? There was a recording made of Bone, right? And this Bone,
I heard that recording before.
And this tape right here, if Suge would have went to trial, it would have vindicated him. And basically on the audio was Bone, you know, running his mouth like he do, speaking up on shit that he, you know what I'm saying? He just can't shut up. So, you know what I'm saying? So basically he talking about who paid him to attack Suge and all the shit. And so,
wow.
And so long story short, at the time, Cash was acting like he was, you know what I'm saying, finna get the homie Suge a lawyer, right? And so he was pump faking with fake receipts, talking about he, you know, retained a lawyer for Suge and this and that, right? But the whole time he was trying to get the death row rights. And so basically he talking all that shit right now about Suge because he mad because he couldn't get the death row rights. You hear me?
So he did not get the Suge Knight rights, but you're saying that's what he wanted to ultimately
that was his whole goal of initially getting involved, trying to get Suge a lawyer. Now what happened was, once he found out that he couldn't get the rights to the movie, to the death row exclusive, he pulled out on the lawyer. And that's why Suge was saying that he the reason that he got 28 years. So Suge was forced to work with a public defender. and the public defender railroaded him and took a deal. You know what I'm saying? But all that shit Wack talking about, trying to down the homie, talking about he broke and got knocked out. Me and niggas been knocked out. Just because you get knocked out don't make you a buster. You feel me?
Right.
And, you know, speaking up on a nigga name while a nigga in jail, that sucker Buster and Mark shit. You hear me? When that nigga was on the streets free, that nigga was quiet as a church house mouse. You feel me? So, and that's just basically what it is. I'm not on here to throw no smut or make nothing up. I'm a real nigga from Inglewood, for real. You feel me?
So tell me this, right? You said that he was sliding the fake receipts like he had retained attorney and counsel for him. But
yeah, I met up with Cash at BJ's at the Fox Hill Mall, like 2017, and I had the audio of Bone, and he was supposed to hire an attorney, and they was going to use that for Suge's defense. But however, like I say, once he found out that he couldn't get the rights to the movie, you know what I'm saying? He sandbagged on the homie attorney.
Dang.
So that's really what happened. So all that other shit talking about, the homie got knocked out and this and that. Ain't no smut on the homie name. He ain't never did no buster shit. Can't nobody on the planet say Suge done some buster shit. Everything he done was gangster, whether you liked it or not.
So when he came in here, he said that he said that you had recorded that conversation. Was that you?
Yeah, that was me. And it was part of Suge's defense to free him.
Okay, now when you say that you come with these allegations that Wack's supposed to slid him fake receipts like he was retaining an attorney, do you have copies of those fake receipts?
Nah, he was just basically showing me this shit in his phone. You know how he talk real fast and you know everything on power rule. You know he was. You know what I'm saying? Like I said, we had a meeting, me and him. You know what I'm saying? It was just me and him. You feel me? He's supposed to, you know what I'm saying, retain the attorney, pay for the attorney, but he pulled out once he found out he couldn't get the rights to death row. Because you remember, and I'm going to tell you, if you go back on YouTube, the nigga was saying, Suge will be out in 90 days. Do y'all remember that? It was a couple years ago.
Yeah.
You feel me? So he basically is the snake digger. You feel me? And all that shit he paid for the homie mama funeral, nigga, you wanted to do that. Nigga didn't beg you to do that. You did it on your own. You feel me? So that's pretty much what it is. I'm not nigga come on here and make no smut up, or I'm not finna say nothing fake. Everything I'm saying is 1,000. You feel me? But as far as you nigga talking about a nigga working with the nigga did some police shit, never, nigga. He did the police shit with the 6ix9ine shit. I recorded the rat. You feel me? He interviewed the rat. It's a difference.
You recorded the rat?
Yeah, Bone. Bone.
That's a serious allegation. I mean, what?
I got receipts. I got paperwork. I
don't know if D-Dog actually had the paperwork, but I did break down the paperwork so y'all could go on the channel. I did expose the paperwork on Cleabone Sloan. Let's go.
Put it on YouTube. I'll tell you how to find it right now.
What can we find?
16 pages.
What can we find?
Who's he calling the rat? Who's he calling the rat?
Yeah, what can we find that at?
What can we find the paperwork at?
It's on here.
It's on YouTube. It's been on YouTube for over a year already.
Post the link. We need to see that.
What's the link? We need to see that.
Yeah, send that.
That's on Bone.
That's some serious
You
allegations.
talking about Bone?
Yeah, that's a serious allegation.
That played on First Watch. We talking about the same Bone, right?
Yeah, that's same Bone.
That's what it
He
is.
should just let it be known that didn't nobody know that conversation was being recorded but him. You should let that be known.
So that's the Minnesota meatball. Big Snow from Minnesota. The rat. CS2 back has sent them to my stage. A spy. He's feeding them what to say. See, CS2 back been obsessed with what I got going on for years now. We wasn't even beefing at that time. But he had spies on me because he sensed the threat. Let's go.
Oh, that you said, who is that saying that?
Yeah, that's Snow saying that, and dude should let that be known. He's the only one that knew that that conversation with Bone was being recorded, and they was talking about a whole bunch of shit in that conversation that shouldn't have been recorded.
Hey, do you hear that, D-Dog?
What do you say?
That you was the only person that knew that that conversation was being recorded, and a lot of shit in that conversation that y'all was talking about shouldn't have been recorded.
Yeah, just like I'm the only nigga that got paperwork on nigga that I recorded. I got paperwork on him.
But
Yeah.
you was the only person, like, wasn't you the homeless dude that Bone?
Hey, D-Dog, listen. Recording the rat, I ain't got a problem with you recording the rat. Fuck that rat ass nigga. But as far as recording the rat to give it to the DA so that Suge could get a time cut, that's third party cooperation, bro. So I don't agree with that, especially when it's talking about other crimes. Now, if it was just talking about this crime, that's the difference, because that means the snitch lies snitch and you got evidence. But when you get to talking about other crimes, I don't know, D-Dog. I ain't with that, my nigga.
Gave a job and somewhere to stay to go to run to the store and shit like that?
No, that's the wrong nigga, homie.
Okay.
You got the wrong nigga.
Here go the lies in the camera.
I mean,
Wack also said you tried to sell the recordings.
Bang that like button.
He did,
listen.
Dude is capping,
This is what you do.
So he tried to sell Wack the recordings of Bone for $30,000.
Ask Wack how he got the recording.
Capping, bro. This nigga was recording them in a car. Nigga, wallahi. He's lying. And he's capping.
Bro, shut the fuck up, bro. You don't even know me, nigga.
Yeah, Snow, how you know?
I'm
you
glad
around this nigga or something?
Hold on. So,
bro,
so
I just was on the phone
so
with
Snow,
one of the
you know
people
what
who
he's
was-
talking about, right?
I was just on a three-way call with the person who was being recorded. That nigga didn't know he was being recorded.
He's a rat, nigga. I got paperwork on the nigga. Do you hear that part?
Fuck would you even be conversating on any of that if the purpose of the recording is just to get Suge out of jail?
Blood, shut your ass up, nigga. You talk too much, nigga.
How?
Okay.
Nah, because now he's
How?
speaking.
Because
Nah,
you
he
the
just
police.
speaking facts.
Cause you the police, nigga. Come on, bro.
Wow.
And you in here like you a rat, my nigga. You was a homeless nigga that had nowhere to live, and Bone gave you an opportunity to work and be a store runner on the set.
Shut your dick, shut your suckers up, nigga. You the bitch, nigga. Shut up, nigga.
Car that don't nobody know.
Hey, why he gotta shut up, bro? How?
One
Hey,
mic.
who is that talking? Hey, who is that talking though?
D-Dog, we finna get to that. All right. Now, D, nobody should be talking. Y'all talk back and forth, but try to keep it respectful. That's the only way we gonna be able to get to the truth.
Right here. Here you go, right here. Right there.
All right, now D, what you say you wanted to address him? The dude that was talking to you, go ahead.
Yeah, who is that?
So, dude, Bone didn't give you no job, right?
No. I got hired by F. Gay Gray.
So when Bone,
so first and foremost, listen.
he
Don't listen to nothing Wack tell you, blood.
That's not Wack Bone personally, bro. You don't know who you talking to.
Blood, you don't know who you talking to, nigga.
So did you used to live on Budlong?
No.
Oh my God, here we go with the lies. So you wasn't living on Budlong?
My nigga, I just told you.
Or was you not living on Budlong?
I said no, nigga.
This nigga, hey, Lamonte, he's lying, bro. I'll bring Bone in the room, bro.
Hey,
bring him in right now.
Yeah, bring him in. Bring him in. Bring him in.
This nigga, bro. This
Fuck
nigga's
talking to you,
bro.
nigga. You's a nobody, nigga. Bring Bone in here, nigga.
I'm a nobody with way more money than you, bro.
Nigga, you's a nigga.
But you the one that told on the nigga.
Nigga, I ain't getting no telling, nigga.
But you recorded.
You's a boy, nigga. Shut up, nigga.
So with Suge being set up for Suge getting 28-year deal on the accidental unaliving of Terry Carter and the running over of Cleavon Sloan Bone. Bone telling, Bone being recorded saying that Dr. Dre paid him. I got the actual check that was paid to the dude. You know what I'm saying? From Andre Young. Which seems like it was a covert plot to get him out the way. They wanted Suge out the way. You know what I'm saying? So let's see what the people say. Based upon the RJA and Suge Knight coming home soon. Okay, so y'all read what y'all heard it how I heard it. 85% say yeah, 15% say no. The 15% who said no, I want to hear why y'all say is it no. Is it because y'all like me, y'all don't believe in the judicial system? You know what I'm saying? Why is it no? Keith McCulley, what up, bro? Groovy, I got that. Hey, Lou from the Lou, got that too. Salute, bro. Both of y'all send me y'all mailing address or a P.O. box, man. I got something coming to y'all. We finna get this merch back cracking. I wish I could show y'all my thing. I'll pick up the my press machine. I got it at Maria Mom house. I should come home and Puff in the feds. That's crazy. Now Puff should be getting out, bro. He should be getting out probably at the end of this year, beginning of next year. DUSE, Birdo, salute, Damu, Kiwe, conversation. Damu, Kiwe. Did you see CS2 walk Ray J in the court today? Wack was out of breath just from walking. No wonder he duck and fade. He just fat, bro. A fat midget, bro. Them alligator arms. He that's why he duck and fades. He probably was ducking fades at the courthouse. That's not my name anymore. Hey, y'all. I wish he had other violations to show other forms of misconduct to add to the request. Right. So wait, Nubian Queen, Raiders. So you think, is you one of the ones that don't think he coming home? For anybody who don't think he coming home, please put it in the chat why y'all think not. Man, it's almost 2 hours. We got 8 minutes. I'm going to kick it with, it's lovely. Now, hey, y'all. Say y'all. Hey, now. Say now. Okay. Wack got knocked out by J-Rock. Fact. Wack, a.k.a. Clayface. Just because you broke doesn't mean you're not a man or a woman. Right. Wack being knocked down more than bowling pin. He just master manipulated to the gullible. LaRue. Slick talking. Because you have a warrant like I had today, don't make me a thug. Yeah, I had some tickets I forgot about. Damn, you had a warrant? Luke Gage, salute, bro. Oh, well, I'm going to take my ass to sleep. It's 12 o'clock out here, man. I don't see nobody saying why he ain't getting out. No, man. If you're just coming in, don't forget to hit that like button. You know what I'm saying? Mike B. Suge finna come out to Doe having his own life right. Man, that nigga, that's going to be $1 billion at the box office, nigga. Can't nobody tell that death row story like Suge, nigga. Nigga, that shit going to be billions, nigga. Nigga, you got to get... Nigga, oh my God. Man, I think Jimmy Iovine and them gonna get that brother whacked before he put that movie out, because it's gonna expose all his foul shit. Free Suge Knight, Vancouver, BC in the house, mad respect. Salute, shout out to Canada. Vancouver is in the building, you know what I'm saying? That's why you don't want no fade. Quit hating. I'm in the Northwest Vancouver. Okay, Birdo, get it. All right, Keith McCulley, let me see. Yeah, I think he getting out. Raider Q say he getting out. He has a grandson to come home to. Yeah, man, Dr. Dre might go in the hide. Yeah, Dr. Dre gonna go. Hey, look, everybody, bang that like button. Listen, man, it's 12 o'clock. I got to take my ass to sleep. Till then, in the morning, we got a gang of content. So turn on the notification bell. We going to bring y'all that mail. Till then, it's DUSE Sims done. Thank y'all for supporting Damu Kiwe.